Okay, welcome back. And tonight we are going to talk some more about the Jefferson administration and hopefully the Madison administration and what happens constitutionally during this period. Now, I think I mentioned last time that Aaron Burr did not ingratiate himself to Jefferson by his actions in 1801 when the Congress is deliberating whether Jefferson or Burr should be president, and Burr said he didn't really have a stake in this, that it was up to the Congress to determine which one would be president. It would be, how should we put it, presumptuous of him to tell Congress how to vote. And this, and then of course Jefferson does become president, Burr becomes vice president, presides over the Senate, and actually that is following a custom that had been established during the Washington administration of the vice president not having much to do as far as the executive branch goes. Washington had kept Adams at arm's length. Adams had kept Jefferson at arm's length. Of course, they represented different political parties, so that was understandable. And Jefferson kept Burr at a distance, so Burr's role really was in the Senate. And then as the 1804 rolls around and there is going to be a presidential election. And remember, the Republicans in the 1790s had gotten well organized as far as deciding who would be their candidates. And also, and then there was a constitutional amendment so that one actually would be running for president and the other for vice president. Burr wasn't going to be asked again to be the running mate of Thomas Jefferson. So instead, George Clinton, the governor of New York, became the vice presidential nominee. Now, this is all kind of the big political, well, not really a big political story, and whoever the vice president is, typically over the 220 some odd years of the Constitution hasn't mattered a great deal. And Burr was a very ambitious, very powerful political figure still in New York, and there was in 1804 an election for governor of New York, and Burr was backing one candidate, and our old friend Alexander Hamilton was backing another candidate, and Hamilton, as I think I mentioned, was publishing the New York Post, really vocal anti-administration paper, constantly attacking the Jefferson administration, pointing out its ineptitude, its malfeasance, and other things. Now, during the course of this political campaign in which Burr and Hamilton were backing different candidates, one of them was heard to question the other one's honor, saying he's not a man of honor. And in the 18th and early 19th century, there was nothing worse you could be than a man without honor. And the only recourse, if someone charged that you were a man without honor, was to demonstrate you were a man of honor. And the way to prove that you were a man of honor was what? Yeah, challenge the person to a duel. And dueling really came into fashion in the United States during the Revolutionary War, and it was brought by French officers. And the whole idea of dueling is it's an affair of honor, is what it would have been called. They wouldn't say, I'm going to fight a duel. I have an affair of honor, a way of proving your honor. And the purpose of a duel is not to kill the other guy. It is to stand there and show that you are not afraid of him, that he can fire at you and you're not going to win. So, I mean, how else can you demonstrate that you're a man of honor other than by standing there, letting someone shoot at you? And he's not trying to kill you. In most duels, the one or the other guy doesn't die. And it's an elaborate formula I don't need to get into here, unless anyone here is planning one of these and you want some advice. And actually, according to the code, you and the other party can't exchange any words until you've actually fired at one another. Your seconds are the ones who will, they'll usually try to negotiate a settlement. The fact that here Mr. Isco and I are standing here facing one another, our seconds will say, isn't that evidence that I've recognized you as a man of honor? And that's usually how we would arbitrate these things afterwards. And usually we will fire low to hit the other guy in the hip or nick him in the leg or in the side and not to kill him. Okay, so that's just the background here. Affair of honor, illegal, but one of these formulas or one of these social customs that emerged after the revolution and really persists as a political, a certain cultural tradition into the era just before the Civil War. Anyway, in the Navy, for example, the most likely people to fight duels were the midshipmen, who typically were teenagers. And you may be more aware of this than we are, Mr. Hook. The teenagers sometimes are more conscious of their honor than are, those of us who have grown up and can take a few slights, So, the midshipmen were, really shooting at one another in such a way that it became a bad thing in the Navy. Anyway, getting back to the story of Burr and Hamilton, one accuses the other of being a man without honor, and so the consequence is challenges are issued. Yes? I believe it was Hamilton who accused Burr of being a man without honor. And that means since Burr was the one accused, he then would issue the challenge. And then it would be up to Hamilton to say how he wanted this fought. With pistols, how many paces, those kinds of questions. Now, interestingly enough, Gore Vidal wrote a novel about Aaron Burr, which I recommend. It's a really interesting novel. Vidal is a great novelist and has a different perspective on Burr, really, than any other American historian who's ever written about Burr. And Vidal's take on this, we know that the reason for the duel was one said the other is a man without honor. Well, you're writing a novel in the 1970s. How is that going to make sense to Americans that one guy is going to kill another because he said he's a man without honor? You say worse things about me all the time, right? So, has anyone read Burr by Gore Vidal? Because there, as a way of making this understandable to more contemporary Americans, the charge actually is Hamilton said Burr was having an incestuous relationship with his own daughter. Okay, so, yeah, we can understand that being a big thing, but not the, maybe in the light of, recent Hollywood episodes, maybe not. But yeah, so that's something that you could get two guys out to kill one another, but the man without honor, no. By the way, the incestuous relationship with Theodosia, no. Okay, that wasn't ever in contemplation. So I'm sorry for bringing it up. Can we roll back the tape and erase that part? So, okay, so anyway, here we have Burr and Hamilton dueling at Weehawken Cliffs just across the Hudson River from Manhattan. And according to the New York Post, which covered this quite extensively after the fact, Hamilton had said he was going to fire in the air. Okay, that's sometimes what you would do if you wanted to show you really were a man of honor. I'm not even going to shoot at you. I'm going to shoot up in the air. And Burr didn't fire up into the air. And Hamilton was mortally wounded, was rowed back across the river to Manhattan, where he died. Very sad thing for the Hamilton family and for, well, I don't know. I've always, as a Jeffersonian, I've always had mixed feelings about that episode. And I suppose as I get older, I become more sympathetic to Hamilton's side of things. So anyway, that has absolutely nothing to do with what happens next with Aaron Burr. Okay, he is under indictment for murder in New Jersey. He does continue to serve as vice president. And as you probably know, this was the last time a vice president shot someone until Vice President Cheney went hunting a few years ago. And then Burr leaves office as vice president. The senators all could understand dueling, And quite frankly, the Republican senators were not that overcome with grief that someone had gotten Alexander Hamilton out of the way. And then Burr goes off. But what does he go off to do? And that's the big question. In 1805, 1806, the Jefferson administration, well, I should say the administration as though it's a big thing, the governor of Kentucky, or someone in Kentucky, reported to the governor that there were strange goings-on the Ohio River, that former Vice President Burr was in the area, and he was talking to lots of people about the possibility of raising a military force. Now, they're way out in Kentucky. They're not in tune with how President Jefferson feels about Aaron Burr. Aaron Burr is saying, I've decided not to be vice president anymore. And so that's what they know, okay? And here he is saying we should raise an army. And for various purposes, not necessarily clear. Is he raising, well, if he wants to raise an army, why didn't he do it through the existing army? Why didn't he ask Jefferson for a commission? You could ask those kinds of questions if you're really savvy, but if you're not really savvy, you'll simply say, former vice president wants to raise a military force out here to protect us against the Spanish. And he may say, we're going to raise this army and go to New Orleans and then invade Mexico. Well, why is the administration aware of this? Is this one of Jefferson's plans to grab Mexico from Spain at this particular moment? The general who is in charge in Louisiana, the governor of Louisiana, was General James Wilkinson. Is anyone here a descendant of Wilkinson, partisan of Wilkinson? He was just a notoriously corrupt guy. He's the governor of Louisiana. He has an annual stipend from the Spanish government to keep things friendly towards Spain and New Orleans. So whose side is this guy on? And, here, now Burr comes down to New Orleans to talk to Governor Wilkinson about this. And is this something the administration is sanctioning, raising a military force out in Kentucky, Ohio, the western part of Virginia, to grab the Mississippi River? And Burr had said things about, the Jefferson administration is hopelessly inept, things that actually Hamilton had been saying in the New York Post. Can't possibly hold on to this territory. What we could do is create an empire based in New Orleans that would separate the western part of the country from the eastern part, and think about it, the whole Mississippi River Valley as an independent country. So there's that story that starts coming back to Washington. And someone reports this to actually, the State Department hears it. Well, James Madison hears about it. And Jefferson gets a letter from the governor of Kentucky saying there are really strange things going on out here. People who now are affiliated with Aaron Burr are stockpiling weapons on an island in the Ohio River. Do you know anything about this? And Jefferson asks Madison, do you know anything about this? And, well, according to what I know, they didn't know anything about it. And so Jefferson asked Madison, knowing that Madison understood how the Constitution worked, if there is some sort of conspiracy against the United States going on in one of the states, what can the United States government do about it? And what can the United States do about it in 1805, 1806? Conspiracy against the United States going on in Kentucky, some mysterious thing happening. Excuse me? What?
You could charge that person with treason.
How so? This is a good question. What is treason?
Conspiring against the United States.
Well, the Constitution, it's the only crime defined in the Constitution. And we know that Jefferson and Madison are strict constructionists. Okay, so here you have a definition of treason. And it says, treason against the United States shall consist of, in levying war against them or giving aid and comfort to their enemies. It doesn't say anything about conspiring. It says levying war, giving aid and comfort to their enemies. So has anything that happened so far been levying war against the United States, giving aid and comfort to enemies of the United States? No. Bunch of, weapons being stockpiled, conversations between Aaron Burr and a lot of other disaffected people out west, but no war. And then it also says what will constitute proof of treason. You can charge someone with treason. I've already said it's a rather narrow thing. And it says conviction will conviction will rest on confession in open court, or the testimony of two or more witnesses to the same overt act. Okay? So if we charge Burr, it means we have to have him confess in open court and not in some secret conclave, or we have to have at least two people who can see the same overt act, overt meaning open, an open act of levying war against the United States, giving aid and comfort to their enemies. So that means if Burr does actually take these weapons and attack Washington or attack any federal installation, then you could say, okay, that is levying war, and you'd have to have at least two people who saw him do that. But if you have two people who saw him stockpiling weapons, and then you had two different people who see him using those weapons against a federal installation, is that enough to convict him of treason? If, let's say, it's only one person who sees each. No. You have to have two to the same act. So it's a complicated thing. Now, the administration, after hearing more evidence and more speculation, takes action and has Burr arrested. He's arrested down in Mississippi, charged with treason, and is brought back, actually on foot, in manacles, to stand trial in Richmond, where the trial in the summer of 1807 is presided over by John Marshall. You'll recall the Judiciary Act of 1802 said now Supreme Court judges will ride circuit. John Marshall's circuit includes Virginia. The indictment's handed down in Virginia. So in the federal court in Richmond, actually held in not in a tavern in Richmond, in the state capitol, Aaron Burr, former vice president, charged with treason against the United States, and John Marshall presiding over this trial in Richmond. Really a fascinating trial, fascinating set of circumstances. You can think about this other applications. Burr and Jefferson have certain personalities, but imagine then the implications, other political figures who fall out of favor, and there have been political figures who fall out of favor in the United States since then, could be charged with treason if you can, say, construct a case against them, which is what the administration did. They acknowledge, okay, no one actually saw him committing an overt act of treason, but we have lots of steps here. We have constructive treason. That is, all of the steps leading to treason, we nipped it in the bud. And actually the chief witness against Burr is General Wilkinson. Kind of sees which way the wind is blowing and begins giving his own side of the story. How, Burr really wanted to separate the whole country and set himself up as emperor of Mexico, et cetera, et cetera. One of the Navy officers who attended the trial made a bet with another Navy officer that the court would never believe this guy because he was such a crook. But surprisingly enough, the administration did. Okay, so complicated constitutional story here about Aaron Burr, as well as a political story about Aaron Burr. And then it gets even more interesting because Burr's whole case is, I was doing this with Jefferson's full knowledge. We talked about it. He knew what I was doing. Okay? So how would you prove that if you're Aaron Burr? He was vice president. Okay, good. But how would he prove that Jefferson knew I was doing this? Written documents, letters from Jefferson. There aren't any. Jefferson's too smart to write to Burr saying, good idea, raise an army, invade Mexico. He wasn't, he's not writing to Burr if he does have any written documents. Anything else you can do? Excuse me? Memo to file. Okay, he could perhaps have written. What proof is that? Mike writes down today, this happened. I suppose that could be evidence. But Why not have Jefferson come and testify? Why not? Actually, I should tell you, too, Burr has a very good lawyer in this. Our old friend Luther Martin. Defends Burr and has the president subpoenaed to come to Richmond and explain what it was he had told Burr. So the court issues a subpoena on President Jefferson, summoning him to appear in court in Richmond to testify in the case of United States versus Aaron Burr. And then that raises this other question, which is, should Jefferson go testify in Richmond? Sure, the president has to obey the laws, and he has just as much obligation to obey the laws as anyone else, which is what the court says. That, he does have to obey the laws, and here his testimony is required in this case, and so the court will issue a subpoena, which is, from the Latin, or I guess it's Greek, under penalty, right? Under penalty of what, if you don't answer a subpoena? Has anyone here not answered a subpoena? What is the penalty? You go to jail. Okay. Yeah. Okay. So the court orders the president to come to Richmond and testify in the case. And what would you do now if you are President Jefferson? Excuse me? Executive privilege. That's a term that hasn't been coined yet. Coined under somewhat similar circumstances a couple hundred years later. These are things that haven't been defined, and this is one of the moments when the issue is going to be defined, because it's not an abstract issue now. You have a court, actually presided over by the Chief Justice, issuing a subpoena on the president, and the president ignores it, and the court issues another subpoena, and the president writes an extraordinary letter to the chief prosecutor, George Hay, who is an attorney working in the Justice Department, saying, I did not see until last night the opinion of the judge on the subpoena against the president. Very abstract here. The judge is John Marshall. The president is me, okay? I did not read his argument with much attention. Yet I saw readily enough that, as is usual, where an opinion is to be supported, right or wrong, he dwells much on smaller objections and passes over those which are solid. Jefferson and Marshall were perhaps the two best lawyers in the country. And, Jefferson had a very low regard for Marshall's judicial opinions, actually for their outcome. Okay, but this is a good critique. He spends a lot of time on the small objections, but ignores the big ones. Okay. Laying down the position generally that all persons owe obedience to subpoenas, he admits no exception unless it can be produced in his law books. But if the Constitution enjoins on a particular officer to be always engaged in a particular set of duties imposed on him, does not this supersede the general law, subjecting him to minor duties inconsistent with these? Okay, he goes on. The Constitution enjoins his constant agency in the concerns of 6 million people. Is the law paramount to this, which calls on him on behalf of a single one? What do you make of that argument? The president is responsible to 6 million people, yet here is the Chief Justice saying, you now are responsible to this one individual. Okay, let us apply the judge's own doctrine to the case of himself and his brethren. The sheriff of Henrico County summons him from the bench to quell a riot somewhere in his county. The federal judge is, by the general law, a part of the posse of the state sheriff. Would the judge abandon major duties to perform lesser ones? What do you make of that argument? You know, as a citizen of Henrico County, he has to do, serve on a posse and go quell a riot somewhere. Should he? Well, Jefferson would like to ask these rhetorical questions that don't have an answer. Again, the court of New Orleans or Maine commands by subpoenas the attendance of all the judges of the Supreme Court. Would they abandon their posts as judges in the interests of millions committed to them to serve the purposes of a single individual? You can see where this is leading, right? All the judges now have to go up to Maine to testify. Then they have to go down to New Orleans to testify. The leading principle of our Constitution is the independence of the legislature, executive, and judiciary of each other. None are more jealous of this than the judiciary. But would the executive be independent of the judiciary if he were subject to the commands of the judiciary and to imprisonment for disobedience, if the several courts could bandy him from pillar to post, keep him constantly trudging from north to south and east to west, and withdraw him entirely from his constitutional duties? Right? So he's going to be traveling around the country, testifying in courts the whole time he is president, if he has to answer a subpoena to go appear in this particular trial. The intention of the Constitution that each branch should be independent of the others is further manifested by the means it has furnished to each to protect itself from enterprises of force attempted upon them by others. And to none has it given more effectual or diversified means than to the executive. Okay, each branch is supposed to be independent, and none is better able to protect its independence than the executive. That sounds like a threat to me. Okay, again, now Marshall drew on an example in London where ministers of the government could be summoned into court. Okay, again, because ministers can go into court in London as witnesses without interruption to their executive duties, it is inferred that they would go to a court 1,000 or 1,500 miles off, and that hours are to be dragged from Maine to Orleans by every criminal who will swear that their testimony may be of use to him. Okay. The judge says it is apparent that the president's duties as chief magistrate do not demand his whole time and are not unremitting. This is a quote from Judge Marshall. If he alludes to our annual retirement from the seat of government during the sickly season, every summer Jefferson would leave Washington and go to his mountain retreat in Monticello, because he said he wouldn't spend the summer on Tidewater. And Marshall is pointing this out. It's clear he's not busy all the time, right? His duties aren't unremitting. And Jefferson took that for what it was. If he alludes to our annual retirement from the seat of government during the sickly season, he should be told that such arrangements are made for carrying on the public business at and between the several stations we take. It would take about 5 days to get there. As if we were at the seat of government. I pass more hours in public business at Monticello than I do here every day, and it's much more laborious because all must be done in writing. Our stations being known, all communication comes to them regularly as to fixed points. It would be very different were we always on the road or placed in the noisy and crowded taverns where courts are held. So, should Jefferson testify in Richmond? Mike's saying no. Yes?
I think he should pick someone to send as representative.
Well, how would you, I could pick you to send as my representative somewhere. How would you know what I had said?
You spend a bit of time telling them, but not as much time as it would take.
But then that would be hearsay. Okay, he told me this is what happened. No one can cross-examine you about what I've said to you. All you know is what I said. That's an interesting idea, though. Jefferson does actually submit a written statement saying he didn't know anything about it. But again, you can't cross-examine a written statement. So Jefferson and the executive branch win this one. He doesn't answer the subpoena, and no president will be subpoenaed actually until 1973. Okay, so that's a big story here, as Jefferson, refuses to answer because the executive is independent of the judiciary, and plus that line, no one has a better means of protecting itself than the executive. So there, what are you going to do? Arrest the president for not answering a subpoena, not going out to Richmond and testifying? And then Jefferson makes this broader argument about responsible for 6 million people having to go and testify in Burr's trial would take him away from that. Yes?
Based on your argument, I agree with Jefferson for not testifying, but the question is, could he have been impeached by Congress?
Okay, that's a good question. Okay, he refuses to answer the subpoena. Could he be impeached? Well, sure, if Congress thought it was an impeachable offense. His party controls Congress, and there's no way they're going to impeach him for this. They were glad Burr was gone. And so, impeachment, yes, it is a constitutional check, but it's also a political check. And, you can't impeach someone if, a majority in the House of Representatives thinks he's right. Okay? We'll come to actually, that's going to come up a couple of more times and as an issue in conflicts between the court and the executive, as the court will suggest that there are ways of dealing with a president who is not doing what the court wants. Yes?
You could then reason that the entire executive branch is exempt. If the executive branch is separate from the judiciary,
Yeah.
then how can it command its obedience?
Yeah, that's right.
And you could then just...
Yeah. Okay.
It really isn't right that if you have the rule of law, that the president doesn't have to testify.
That's good, because that's a very good point.
It's not pure.
Right. That's a good point. Yes.
The only argument is expedience.
That's right. That's a very good point. Does this cover the entire executive branch? And does that mean, not that it is independent of the judiciary, but that it's completely above the law? And that's the question. And that's not resolved here. And ultimately, in the case, the next time this comes up in the 1970s, the Supreme Court says that executive privilege, as it comes to be known, does not cover criminal conspiracies. It does cover the legitimate actions of the executive. But then that's a question. Well, how do we know? This may be something we think is constitutionally wrong they are doing or politically misguided that they're doing. What is to stop them? It's a tension that's at the heart of the system. It can't be resolved. And it's a tension, as your question suggests, it's something that is going to have political resolutions that probably aren't going to satisfy us depending on our political point of view. So, at the moment, Jefferson doesn't testify in Burr's trial. And at the trial, to move on to the next point here, the second issue is, what is treason? And it's something we kicked around earlier. The administration says, we have all of this testimony about the different steps that Burr was taking that suggest that there was a treasonous conspiracy going on, and the court, in the judge, tells the jury there is no such thing as constructive treason. The Constitution defines treason: levying war against the United States, giving aid and comfort to their enemies. And nowhere in this record do we find the defendant, Aaron Burr, levying war against the United States or giving aid and comfort to their enemies. And none of the witnesses have seen him performing an overt act of treason. So the court, doing what I think, Jefferson, had he been a strict constructionist even when he was dealing with John Marshall, would have seen that is strict construction. It is looking at the text of the Constitution, which very carefully defines what treason is, and doesn't extend it, saying, oh yeah, there are all these steps that are necessary to perform treason. It's a case where, Jefferson is taking a more expansive view of constitutional interpretation than John Marshall. And, I don't know, what do you think? Good thing or bad thing that we've constricted the definition of treason to what the Constitution says?
amassing this essentially arms and army?
Well, we don't know that.
Wait?
Okay.
Do you wait
Yeah,
to get attacked?
that's a good question. Well, that's a very good question. Should we wait until he does levy war on the United States, or give aid and comfort to their enemies, or do we nip it in the bud? That's another question we can't really answer. Unfortunately, it is flawed, as you say, it is flawed. I'm not quite sure I agree. It's actually something we will come back to in 1861. Okay. Yes, Mike.
Were there any other laws that on the books, federal laws that made Burr's actions illegal?
No, that's a good question. This is why there were no federal laws against doing this, so he wasn't breaking any laws. And according to him, he was doing all of this with Jefferson's knowledge. And had Jefferson come to testify, his lawyer probably would have gotten it out of him. This is Burr's side of the story. Burr is acquitted, incidentally, because he didn't commit treason. He didn't levy war against the United States or give aid and comfort to their enemies. Yes?
Do we think that Burr did this on purpose?
Did what on purpose?
Does it say that the president said that he could?
Yeah.
Just to cause him to be the president?
I don't know. I mean, that's a good question. These are some of the things that make history fascinating, because you can't find, Burr always maintained that, Jefferson knew what I was doing. And also, he didn't, very interesting life story. Burr ultimately, goes back to New York to practice law, and quite successful lawyer. He spends some time in Europe and then comes back, but deep distrust of Jefferson. Burr had been a great popular hero, but then a deep distrust of a popular hero like Jefferson. In his farewell speech to the Senate, he warns against, people like Jefferson. He doesn't mention any names, but anyway. Yes?
Who exactly charged Burr with treason? Was Jefferson part of it?
Well, yeah, it was the United States government. So that means the Attorney General issues an indictment against Aaron Burr, going to court and having him indicted and then brought back for trial. So the executive branch executes the laws, and so this is the executive branch charging Burr with treason. And an attorney, George Hay, I believe was Attorney General, is empowered then to try Burr, to conduct the trial. So yeah, Jefferson knows about this.
But he didn't make it happen.
He may have. I mean, I don't know that much happened in his administration that he didn't make happen. It's a very small group of guys who are, doing things. And, Jefferson wanted this to happen as a way of, you can think, okay, either Burr was dangerous and was doing something that was going to, break off half of the country, or we need to get Burr out of the way. Who's going to run in 1808? Burr's becoming very popular out in Kentucky, Ohio, and so on. Maybe he is angling to become president. And what would happen then? Yes, Roberto.
Just now that you explained that, I now get it. It could have been a little political game.
Oh, yeah. Well, it was a political game, yeah.
You answered my...
Okay, yeah. These guys are politicians, remember that. Not that that's a bad thing. I mean, we have a system where politics is very important. Okay, any other questions on this, on the whole Burr trial? Great trial. Actually, at the same time this is happening, in June of 1807, the United States frigate Chesapeake, one of the sister ships of the Constitution, goes off to the Mediterranean to perform its blockade duty. Now, the United States is at peace. France and England are at war with each other, but the United States is at peace with both. And the Chesapeake actually had been fitting out in Washington. It goes down the Chesapeake where it is supposed to head out to sea. And apparently the captain in charge, we don't need to get into all the details of this, Commodore Charles Morris, didn't really have the ship well prepared for what it was doing. In fact, when it went past Mount Vernon on its way down to Norfolk, they didn't have the guns ready to fire a salute. All Navy ships would fire a salute when they passed Mount Vernon. the Chesapeake isn't ready, gets down to Norfolk, and then it's at the dock for a while. There's a British ship next to it. And the British in Norfolk are complaining because their sailors are deserting from the British ships and going on to American ships. And the Americans in Norfolk, the officials keep sending the British around to, oh, you have to go talk to the mayor about that. The mayor says, oh, no, you have to go talk to the commander of the port. He says, no, you have to go talk to each individual captain. So the British officials are getting a runaround as they know their sailors are leaving and signing on to American ships where the pay is better and the United States is not at war with France and they're treated much better in the American Navy and so on. I'm not here to boost the American Navy as opposed to treatment in the British Navy. So anyway, the Chesapeake puts out to sea, and just off the coast of Chesapeake Bay, it is stopped by the British man-of-war Leopard. Okay? And the captain of the Leopard signals that he wants to come aboard. He wants the Chesapeake to stop so that he can come aboard and get British deserters off the Chesapeake. What should the commander of the Chesapeake do?
Probably whatever he has to.
Like, what is it that he has to do? I mean, it's easy to say, do what you have to do, but actually, it's a little confusing here. Commodore Charles Morris had been commanding the Chesapeake on its way down, but now it's under the command of James Barron, who is the commodore of this fleet that's supposed to go blockade the Mediterranean. So what should Commodore Barron do now? Has this order to stop, to let a British party come aboard and muster the crew to determine if any of them are British deserters? What? You would say no. Okay. Well, again, let me just say, it takes Barron and his officers a bit of time to decide what they should do, and while the British commander is waiting for an answer, he opens fire on the Chesapeake, killing 3 sailors, disabling the ship, which hasn't fired a shot. In fact, one lieutenant does go below. He sees they're on the top deck striking the flag. He gets there's luggage piled up over all the cannons. Okay, they haven't been gotten ready to go to sea because they're not expecting to meet any hostile ships. And Lieutenant Allen gets a coal from the stove, goes to one of the guns and fires it just as the flag is coming down, because he hates the thought that we're going to let them come aboard without firing at them. The British officers do come aboard. Commodore Barron attempts to surrender the ship. He is told, we don't want the ship, we just want to muster the crew to take off any deserters. They have the crew come up, and they point to 5 guys. They say, oh yeah, you, and you. And these guys then are taken aboard the Leopard, and then the Chesapeake is sent on its way. So now what should the United States do?
Start the War of 1812.
Oh, start the War of 1812. The problem with this is it's June of 1807, and gee, we know, hey, that war's not supposed to start for 5 more years. So, okay, and if we do decide to start the War of 1812, we have to keep in mind a crucial fact, that the Chesapeake is one of about 12 ships in the American Navy, and it's just been knocked out. The British Navy has, I think, about 900 more ships than the Americans do. And they have been at war with France for 20 years, which means their sailors are pretty well prepared. And they've been at this for a while. And they've just shown what they can do to one of the best of the American ships just off the American coast. So you start a war with the British Navy, it's going to be over pretty quickly. I like your spirit, though. Another of these tough questions that doesn't give us an easy answer. And what had happened too, there's a side note here. The British know the Americans are doing really well because we're at war with France. And the Americans are supplying the French and trading with the French. And they're also trading with the British. And the French know the Americans are trading with the British. And each side thinks, if we could stop the Americans from trading with the other side, that would really be good for us. So at about the same time this is happening, the British government says no one gets to trade with the French. And by this time, I should point out, the French control the European continent. Napoleon has moved through Europe, taking control of most of the continent. Okay? And yeah, their armies do depend on grain and other things to keep going. The British control the oceans. So the British say, you can't trade with the European continent because we'll consider that an act of war. If we find one of your ships trading with the enemy, we'll seize it. The French say, anyone who trades with the British can't trade with us. If we find a ship trading with the bad guys, we will seize it. So it's really tough here. What happens that the British have enough ships to blockade the American coast, and this is what happens to the Chesapeake. It runs into the HMS Leopard, and this is why we don't have an attack by a French ship on an American ship. It's a British ship. So what can we do? A strongly worded letter. Yeah, that's good. To whom? A UN resolution. Yeah, first we would have to create a UN so that we could have a resolution condemning this kind of thing. Well, I'll tell you, we don't have those. Well, we do have the strongly worded letter option. We don't have the other option. And what the administration recognizes, we're not in a position to go to war with England. We don't want to simply say, if we do go to war with England, it's pretty much over because we don't have a navy. And the British control Canada and as well as the Gulf Coast. So Spain controls the Gulf Coast and they're on the side of France, although, it's very complicated. Okay. What the Congress does in the wake of this, the end of 1807, is it proposes a Republican alternative to war. Okay? We recognize if we send our ships out to sea, one of these belligerent powers is going to attack it and seize it. That's a bad thing. We also recognize that both belligerent powers depend on us to feed them. What we will do, because we have tremendous resources, the grain of America is feeding Europe, is what the Jefferson administration believes, we'll shut it off. We'll have an embargo. We won't send anything out. No American grain, no American ship will leave port as of the beginning of 1808. We will cut off all American trade as a way of depriving the belligerent powers of the grain they need to sustain the war. And what's going to happen in the short term is this: they'll really be stuck. They won't have anything to feed their armies. This means the people at home will suffer. The people at home will overthrow these governments and become Republican and see that there are better means of resolving disputes than going to war. It's one of the grandest ideas anyone has ever proposed in the history of the world, a Republican alternative to war, using commerce as a weapon and convincing the rest of the world, the people of the rest of the world, not their governments, that you don't fight a war every time you want something. You find other means to do it. So the embargo is a great idea. It's going to be an alternative to war, using the best weapon the Americans have, their tremendous agricultural resources. Shut Europe off from them, and the Europeans will realize the error of their ways. Right? What do you mean it doesn't really work out?
Well, I mean, if the economic, if the whole country's dependent, there's no tax.
Yeah.
Dependent on tariff revenues.
Okay, yeah, okay. So what this is going to do is going to cut off all trade. The Jefferson administration repealed all taxes other than the tariffs. This means there isn't going to be any tariff collected, so the government's going to be broke. I see that. But by the same token, if we go to war, that's going to cost even more. And these ships that we're just keeping in port are going to be sent out to be destroyed. So that's going to destroy trade anyway. If we go to war, it's going to be fabulously expensive and going to ruin commerce anyway. I see your point, though. Yes?
The British still have a large army to force Americans to
Yeah, the British do have a large army. They could send it over and force the Americans to cough it up, but I don't know. Right now they're busy in Europe with Napoleon. Are they going to do that? I don't know. Are they going to divert troops from the European war to the United States in order to get this grain that the United States believes is really important? It turns out in the great scheme of things here, it isn't. I mean, I'll tell you some of the shortcomings of this. I'm trying to stay true to the whole idea of this as a Republican alternative to war. But there's another question here, aside from its practicality or its effectiveness, and that is, does the Constitution give Congress the power to shut off trade? You say yes.
Yeah, the power to set treaties.
Well, that's the president can, and the Senate can make treaties, but this is something different. This is saying, yes. Yeah, Congress has the power to regulate commerce. Well, does regulate mean to stop entirely? Is that a regulation? You would say yes, yes.
Professor, actually, the embargo didn't completely stop commerce because imports were still allowed.
Yeah, but nothing's going out, and you can't import unless you're sending something out.
You could say that there is a regulation.
Okay.
On paper,
Yeah.
it is.
Okay. So you can say technically it is. Well, let me ask you this. Suppose you're a merchant in Boston, and you have a cargo you want to ship out. You now have to go to the customs office and say, I want to leave. And the customs officer says, you can't. It's against the law. What would you do? Look for another carrier. I'll just tell you what does happen. According to the law, things can be sent from one port to another within the United States. So you might go, and actually the governor has to sign this writ saying, he's come to me, he's just taking this cargo of grain to Newport, okay, or hides or something else, to Newport, Rhode Island, okay, coasting voyages. Once you get out off the coast, I mean, you're not going to go to Newport, you're going to go to wherever you can find a market for this. So the governor of Massachusetts actually issues a lot of writs for people who say, you know, I'm just going to Charleston, South Carolina, and it turns out they're going to Barbados or they're going to England. So that's one thing that happens. The second thing that happens, if the customs collector tells you you can't go, you may say, why not? And if you try to go, he might bring a lawsuit against you, or you may bring a lawsuit against him. So actually, this does come into the purview of the courts. And in South Carolina, there's a William Johnson, who's a Supreme Court justice appointed by President Jefferson, and Jefferson only appoints people to the court who share his general constitutional outlook that the Constitution has a document that sets out limited powers of the federal government. And Justice Johnson says that the customs collector does not have the authority to stop a vessel because regulating trade doesn't mean stopping trade. And he orders the customs collector in Charleston to release this particular vessel that's being held. So you have a judge appointed by Jefferson saying the embargo actually supersedes the powers of the Congress under the Constitution. Here in Massachusetts, there's a judge, Judge Davis, who had been appointed to the bench by Washington. He's a Federalist, and Judge Davis finds that, yes, the executive branch does have the power to stop vessels. Now, this is a legitimate exercise of the power of the United States. So it's kind of a mixed bag, what the court thinks about this, or whether the embargo is a legitimate exercise of executive power or not. And actually, it's kind of ironic. The official charged with enforcing the embargo, it's customs collectors who have to do this, is the Secretary of the Treasury, who oversees the customs apparatus, Albert Gallatin. And you may recall that Gallatin first entered politics in the early 1790s in western Pennsylvania protesting against the federal government's imposition of a whiskey tax, a tax on whiskey. Now, as Secretary of the Treasury, he has to send force to places like Oswego, New York, to prevent people from violating this particular law, the embargo law, which as a cabinet officer, he said he urged the administration not to adopt an embargo. You know, for the reason I think you mentioned, this is going to cut off trade. We're not going to have any tariff revenue, and this is going to be a disaster. But Gallatin is enforcing the embargo along the Great Lakes and Lake Champlain, and it doesn't really work. State governors issue exemptions for people wanting to take cargoes to other places. It does have the effect of stopping trade, which means federal revenues essentially stop. And if the United States was going to try to build a navy to fight the British or defend itself, it couldn't because it didn't have anything coming in. No revenue coming in. And also, it turns out England and France don't need American grain as much as President Jefferson thought they did. So this does not bring Europe to her senses. They do not see this as a Republican alternative to war and believe that a political millennium has been ushered in by the administration of Thomas Jefferson. So the embargo is a disaster, doesn't work. I don't know, you folks didn't seem to have constitutional objections to it. Did anyone have constitutional objections? And it expires on March 4th, 1809, the same day that James Madison becomes president. Okay, any questions on this? Jefferson, incidentally, for most of the last year in office, was incapacitated by migraines as the whole policy of the embargo seemed to be bringing the country to ruin. Makes him very even more unpopular in New England than he had been because New England is almost entirely dependent on trade, and this cuts off trade. So, any questions on this? So, Matt, yes?
I don't 100% agree that it was a failure, sir.
Okay, why do you not think it was a failure 100%?
Because that actually is what promoted manufacturing in America and made it more independent economically from Europe.
Okay, you can argue that it promotes manufacturing here because Americans can't import textiles. I don't know. I think that it does ultimately happen with the capital that otherwise would have been going into trade. The guys who had capital accumulated put it into other things like manufacturing cloth.
England happens to be the number one manufacturer.
Yeah.
More so than the South. The South was more here than New England. New England had more development because of the environment than any other
right.
country.
Right. New England also had the rivers that could power generators and also had sent guys off to, basically steal the technology of the looms of England. So, in the long run, New England rebounds, but I don't think anyone in New England says, gee, thanks to Thomas Jefferson, we developed manufacturing. They think it's in spite of the attempts by this administration to ruin them, and they had to do something else. This isn't the beneficent hand of the administration guiding industrial policy and directing capital into better outlets. This wasn't Jefferson's intention. He didn't want to create manufacturing establishments here. He wanted to leave the manufacturing in Europe because he thought, you'd have cities, you'd have all kinds of bad things. So we want to keep this a nation, an agrarian nation with commerce as the handmaid of agriculture, because once you have cities, you have people who are dependent for their wages on someone else, and that will be a really bad thing. So again, we can look at the long-term consequences, which you have. Yeah, the embargo doesn't work to do what it intended, but it does something else. But then the people who created it didn't say, oh boy, those unintended consequences will be great. That's what they wanted to avoid. And they didn't. I don't know. You've raised a good point. Any other points you want to raise on this whole issue of the embargo as a form of policy? Under some circumstances, perhaps it would have worked. Another thing happens. Yes?
Did it make the people angry?
Which people?
Just the people, just the Americans in general,
Well,
to not be able to trade here.
does it make some does, yeah. Here is this administration that talks about leaving men, restraining people from hurting one another, but otherwise leaving them free to regulate their own industry, and the government saying, well, your industry you can't do anymore because it's for the greater good. And sure, it's going to make people angry. So some it does. Others say, well, gee, it keeps us out of war, and we don't want to get involved in this war because it's a war between these two empires. Yes?
I know you discussed how New England reacted to the embargo, but how did the South react?
The South actually remains more Republican, so it doesn't react as against it the way New England does. And that's why Madison is elected president. He doesn't really have any opposition from the Federalist Party. His only real opposition comes from James Monroe, who's a Republican. As New England is seeing, this whole experiment is failing. And they have more votes in the southern states. And it's going to keep leading us to disaster. Okay, why don't we take a break at this point, and when we come back, we'll find out what happens afterward.